let's head to the Supreme Court. Well, today, the court in a unanimous decision turned down a request by the 2020 NDC presidential candidate John Dramani Mahama to be allowed to inspect documents in the custody of the Electoral Commission. These are documents relied upon by the EC to announce the result of the presidential elections. Lead counsel for Mr. Mahama, Chachu Chikata, had argued that access to the document, including the original constituency presidential coalition form and the summary sheets, will ensure a fair determination of the case.
An application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. I don't believe that privilege is an issue here.
Referring to one?
Yes. And one, we have addressed you on the necessity. And we have addressed you by referring even simply to the attachment to Exhibit D, which has been the basis of a lot of cross-examination here and the basis of a lot of explanation from counsel. But that Exhibit D itself, in our respectful submission, shows the necessity for knowing what is the original document on the basis of which we must choose one or the other. What is the original document? That is my submission. In relation to PWD1, and in our respectful submission, those questions are completely irrelevant to the issues that have to be dealt with. Because the question whether he has documents or
My
not.
lords, if I may be heard on this. My lords, I think counsel should argue the application before he... Yes, but the question had nothing to do with what Justice Appa said.
Let me answer myself.
No.
Please. Mr. Chikata, please, that is your opinion. So you keep it to yourself.
Yeah,
whether the questions I asked were irrelevant or not, that is your opinion.
Yeah, but my lord, I need to explain why I'm saying they're irrelevant, so that I can fully answer the question. Because the question relates to the same position that your lordship took. The question relates to that. So I need to be heard on why I say that they're irrelevant. Because I do not say that lightly. I do not say that lightly. I do not say that lightly. The questions are irrelevant because we have brought a petition here on the grounds of a declaration that was made purportedly about elections held on the 7th of December. The declaration stated a figure. We all heard it, 14,300 and 400 and all that. We all heard it. That declaration to this day is the only declaration that has been made. Johnson Asiedu Nketia is not the returning officer of the election of 7th December.
Counsel for John Mahama there, lead counsel for John Mahama, Chachu Chikata. Well, lead counsel for the Electoral Commission, Justin Amenuvo, prayed the court to dismiss the application, saying it is outside the timelines provided by the court.
For the court said this, and with your kind permission, if I may quote it. I hold a view that the application before us cannot be entertained under Rule 5. In my opinion, where a party has difficulty or is in doubt at what steps to take, where there are no express practice of procedure provided, the party must apply to the court for directions rather than, and this is my emphasis, rather than arrogate to himself the powers given to the court under Rule 5.
Mr. Amenuvo.
Yes, my lord.
You see, he came under mutual discovery. That is Order 21-1. Yeah. Then when You look at the proceedings, we've gone beyond that because there was no response from you. And when you do not, allow inspection or whatever of documents, then you can resort to an application under 21(9).
Yes.
And this is the application you are determining. Yeah. So look at the Cogler's case again, whether you can look at Rule 5 of the CI system and apply it to the circumstances.
So my Lord, I refer to the Cogler's case in order to make the point of the timing of this application.
The time.
Yes, my lords. The timing of this application.
Do you have any time frame after the failure of mutual discovery?
My lords, when you are proceeding.
No. Respond to the question. What I'm saying that beyond mutual discovery, do you have any time frame set down under Order 21?
No, my lord, you have to apply to the court.
Yeah, and this is the application you are determining.
Yes, my lord, so the point is that, with the greatest respect, the point is that where CI 99, under which the presidential election petition is filed, talks about timeousness, then when you make an application at a particular point in time, in responding to the application, with the greatest respect to the court, we are entitled to make the point as to the timely nature or otherwise of the application.
Is representing the Electoral Commission, which is the first respondent. Well, Akoto Ampao, who is lawyer for the second respondent, President Akufo-Addo, argues that the first petition, John Mahama, failed to produce, or the petitioner John Mahama failed to produce documents to back the petition, and decision to grant the application will lead to an expedition and undue delay of the hearing.
By the admission of his own witnesses and by law has photocopies of all carbonized copies of all the processes from the polling station right up to the regional level, and then even to the National Coalition Center. They have copies of all the documents through carbonized copies. Therefore, where the petitioner raises a question about the authenticity of any document, he must first produce what he has and show that what he has is different from what the other party has.
So this was the argument about whether or not the counsel for Mr. Mahama should be allowed to inspect those documents. Well, the judges say no new evidence has been given by the petitioner to warrant the court granting that application for the original documents to be handed over to him, the petitioner. Listen to Justice Eninyebua read the ruling.
There are issues of facts between the parties. The court will generally make such an order. However, in the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. In view of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application, we are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant. Order 21 Rule 9 of CI 47, which is the basis of this application, should not be read in isolation. It should be read in conjunction with Rule 11 of the said order. It states thus: an order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly the cause or matter or to save cost. End of quote. Furthermore, Section 166 of the Evidence Act, NRCD 323 of 1975, makes it clear that a duplicate of a document is admissible to the same extent as the original unless a genuine question is raised as to authenticity of the original of the duplicate. No issue has been raised against the authenticity of the duplicates in possession of the applicant. The discrepancies which learned counsel for the petitioner has alluded to in his submissions as having occurred in the declaration of 9th December 2020, the press release of 10th December 2020, and the answer and witness statement of the first respondent are issues of evidence and do not give cause for discovery of the documents under consideration. From the above reasons, the application is dismissed.